And this morning on the Ag Issues program, a pleasure, as always, to bring back to the program Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Good to be with you.
Good to be with you as well. Just mentioning, boy, we hit summer really, really fast.
Yeah, and I was in a cooler part of the country last week, and so it wasn't too great to come back to this.
Yeah, exactly. All right. We got a lot to get to, as always, so let's get to it. This talking about the 2025 Kansas legislative session. Mm-hmm. We haven't had a chance to talk about that, but it's also saw the passage of several bills impacting agriculture, farmers, and ranchers. And let's first just start to go through some of those. SB 89, this is amendments that took place to the Poultry Disease Control Act.
Right. It establishes new fees related to the Act and the National Poultry Improvement Plan. And what it does is authorize the Animal Health Commissioner to set annual participation fees up to $50, annual certification fees up to $50, testing diagnostic fees, $100 per location, and requires performing poultry disease diagnostic services to report the source of certain salmonella findings within 48 hours, and it bars out-of-state poultry from being shipped into Kansas or taken to public exhibitions unless specific conditions of the bill are met. And that one takes effect next week. And a lot of these are going to take effect next week on July 1.
Another portion of the bill for funding specifically, SB 36, that increases conservation districts funding.
Yeah, it doubles it from $25,000 to $50,000 per district and increases the state's matching funding from $1 to $2 for each dollar of county funding. And again, that's effective next week.
And another one actually went into effect in late April. This is Senate sub for HB 2172. But this is concerning the Water Program Task Force and Working Group.
Right. That's what the bill establishes, and their purpose is to study and make recommendations to the legislature on current and future water supply issues and evaluate funding and determine future funding needs for Kansas water programs.
And another one is House substitute for Senate Bill 9, and this is the real property acquisition by foreign principals, not uncommon to see in states here recently, too.
We continue to see this across the country, and Kansas did a little bit on this, not nearly what other states have done on this, but it requires foreign principals from countries of concern, and that basically matches the federal list on foreign countries of concern. And so it requires those types of principals that own or acquire non-residential real property within 100 miles of any military installation in Kansas or an adjacent state to register that interest with the Attorney General's office. And so starting again July 1, foreign principals generally cannot acquire those types of interests. And again, the bill outlines the various notice and divestiture requirements for noncompliance, and it mandates reporting by the Attorney General and Kansas State University on foreign landholdings.
And as an example, well, one would be Fort Riley here in the state of Kansas would be one.
Fort Riley, draw a 100-mile circumference around that, and you've got your, or any type of base. And even if it's out of state, too, if you're within 100 miles of it, you're going to get caught.
Yep. All right. Another one is HB 2111, but this still has some work to do, Conservation Reserve Enhancement Program.
Yeah, this one is stuck in the House Ag Committee. It increases the state acreage cap for CREP from 40,000 acres to 60,000 acres and increases the eligible acres per county from $10,000 to $15,000 to $10,000 to $15,000 acres. 15,000 acres. The legislation, this piece, which again is still in committee, also tries to expand eligibility criteria and potentially allows for dry land farming practices if those practices are approved by the USDA.
So stuck in, I guess it doesn't matter which committee, or Ag Committee, but House or Senate, but still stuck there nonetheless.
That's correct.
All right. Another portion of this is HB 2062. And this has to do with definition of a child.
This is an important one, and this was an override of the governor's veto by the House and Senate here in Kansas, and this takes effect July 1. And what it allows is child support orders for unborn children from the date of conception. and that covers direct medical and pregnancy-related expenses for the mother. Now, excluded from those costs are elective abortions, and you've got a definition of an unborn child here as a living human organism in utero at any stage of gestation. And it goes on to make other modifications to child support guidelines, and it provides a tax exemption for unborn children, and by doing so, it allows a personal exemption of $2,320 for live births and stillbirths that are if you have a filed certificate. And also addresses some retirement account considerations in child support calculations, and allows courts to order the use of individual retirement plan accounts to pay child support arrearages if certain conditions are satisfied, such as income loss or professional license suspension.
All right, we need to move on to a couple of very important cases, both federal and state-wise. And first one we're going to talk about is the warrantless search of private homestead by state officials ruled unconstitutional. Mm-hmm. This has in part, or due in part, associated with the Kansas Pet Animal Act.
Yeah, that's right. And the court has said some of those provisions in that act are unconstitutional. And the core issue in this case, Greg, was whether the act's authorization of warrantless searches of boarding and training kennels violated the Fourth Amendment. And the court said that it did, and they had kind of a lengthy reasoning for it, but they noted that the regulations of boarding and training kennels in Kansas dates back just only to 1991. And that's one of the ways they analyze these types of situations is, have you got a long-standing type provision in the code that allows this? And they said, well, not really. It's only 34 years old. And they said that's not a long enough history compared to industries that are traditionally deemed closely regulated, such as liquor and firearms, that the Constitution is going to apply a little bit differently in those situations. And so the industry wasn't new and emerging when it was regulated in 1991 either. And the court also noted that only 9 out of 50 states have similar unannounced warrantless inspection type systems for kennels, indicating that the operators aren't widely on notice that their property is subject to those searches. So the courts, and again, this is the U.S. Court of Appeals for the 10th Circuit, they found that there would be no clear and significant risk to public welfare posed by boarding and training kennels if they were left unregulated. So an important one for that industry, that you're not going to be subject to warrantless searches anymore. And the court also found, in addition, Greg, that conditioning the mandatory annual license renewal on the operator's consent to unconstitutional warrantless searches violated the unconstitutional conditions doctrine. So the court issued an injunction, prohibits the KDA from conducting surprise routine warrantless inspections of licensed boarding and training kennels, and from penalizing those operators for refusing those inspections or conditioning license renewal on that consent. So if they've got a warrant for a criminal search, that's a little bit different. They can still do those inspections if you have a criminal search warrant or an administrative warrant based on a complaint or with the owner knowing or voluntarily consenting. So it also doesn't affect initial licensing inspections either. But the general warrantless searches are no longer allowed. Those are deemed to be unconstitutional.
All right, another one that has taken place, this, of course, has major ramifications. Mm-hmm. This, of course, with John Deere and the right to repair issues that they have had. But they just recently had a court ruling that case is going to continue. It
will. In the Federal District Court, Northern District of Illinois, John Deere had moved for a motion on the judgment on the pleadings, and the court denied that. So the case will proceed on the allegation that John Deere's repair restrictions violate federal and state antitrust laws. And so it's a big case. And again, this is procedural. I don't want to get into the weeds too much on the procedure here, but that right to repair case, that's the big one in Federal District Court, Northern District of Illinois, is going to continue.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us. And Roger, of course, the reconciliation bill that is in on the Senate side now, of course, there's a lot to take place. Senate Finance Committee just recently released their draft specifically looking at the tax provisions in the reconciliation bill.
That's right, Greg. And this is a real big deal. If they don't get this done, of course, everybody's going to get a big tax increase up and down the income scales, more heavily slanted for those on the lower end of the tax-paying scale. You're going to get a bigger increase starting next year for 2026. And so there's a lot of things they've got to hammer out. And just real quickly, I put out a piece last week saying my top 20 pieces, or what I view as the 20 most important pieces in terms of agriculture that I see that they're dealing with on the tax side of things. One, of course, is the enhancement and the extension of that enhanced increased standard deduction, which Tax Cuts and Jobs Act basically doubled that. That would keep that in the code. And then extending and enhancing the child tax credit, they're still kind of bouncing around on where the enhancement is going to land at. The Senate is currently at $2,000 per qualified child, as well as the refundable portion of that is $1,700. And so we could see that bump up. There's some discussion that might go to $2,500. The House wanted to be much more generous with that and increase that even more. I'm not sure we'll get what the House wanted on that, but perhaps on what the Senate is doing. But that would prevent it from dropping back to $1,000 per qualified child. Another big one, Greg, I have it as number 4 on my list, is the extension and enhancement of the deduction for qualified business income. That's that 20% deduction for business income for a business that's not a C corporation. Of course, C corporations got the lower tax rate in TCJA down to 21%. And for non-C corps, including sole proprietorship farming operations, you get a 20% deduction on your business income. Now, this would be changed to 23%, and then some of the other formulas for service businesses would also be changed. So that is a big one. That's a very important one. There's a lot of talk about the estate and gift tax exemption. If Congress does nothing, that'll be about $7.15 million per person next year. This would take it to $15 million starting in 2026 and index it for inflation. So that is a big one there that would pretty much exclude just about every farming operation out there. Largely, they are excluded right now, but this would pretty much remove that for everybody else. Far less than 1%, subject to federal estate and gift tax. Some of the others here, I have it as 8 and 9 on my list. No tax on tips, and I say kind of, and no tax on overtime, kind of. It's not that they're exempt from tax. It's that it's a deduction that's allowed. So you include the amount in income, and then you back it out. Now, and these are limited in time. This would just be for years 2025 through 2028. So you have a 4-year trigger on these. And for tips, you can deduct up to $25,000. That's the total amount. Again, you have to report it on a W-2 and then back it out. With respect to overtime, you get a deduction of $12,500, capped at $25,000 on a married filing joint return, which is allowed for both itemizers and non-itemizers for your qualified overtime compensation that's reported on a W-2. Again, in the kind of category, no tax on car loan interest. Yeah, maybe. It's a deduction for the next 4 years, 25 through 28, of up to $10,000 for a qualified passenger vehicle loan interest. So they're going to cap the amount of interest you can deduct at $10,000. Now, some may think, well, that's an interesting one, but actually that's an old one coming back. We used to be able to do that 40 years ago, a little bit over 40 years ago, but they're bringing that one back. There is a phase out on that, and there's a phase out on the tax on overtime. There's also a phase out on no tax on tips. So once your income gets up above a certain level, then you can't claim these deductions. They also have full expensing of domestic research and experiment expenditures. Instead of having to capitalize those, a little bit of modification on business interest, exception from limitation on deduction for business meals. So we're going to go back a little bit maybe. We'll see how this comes out, but perhaps to the older rules that we had on that one. And then bonus depreciation comes back for property put in service on or after January 19 of this year. It comes back at 100%. We're sitting at 40% first-year bonus depreciation right now. That would take it back to 100% for this year for property placed in service after January 19. And it increases the amount of expense method depreciation that can be claimed. And so that would take it to $2.5 million, and you would start to reduce the $2.5 million by the amount of your qualified purchases over $4 million in any particular year. They're still kind of wrangling over the SALT cap. You're going to hear a lot about that. That's the state and local tax deduction. The Senate wants to crank that down really low, kind of keep it at $10,000. The House wants to go to $30,000 to $40,000 on that cap. We'll see what happens with respect to that. But those are some of the, I'm kind of picking and choosing out of my list of 20, but those are, I think, the most important ones to keep our eye on for agricultural producers.
The Senate has a target of to vote on it by July 4th. You think that's going to happen?
That's coming up pretty quick. This is going to be a key week in the Senate to see what happens. And, of course, there are other events in the world, too, that they've got to keep their eyes on. So it's a busy time. We'll see if they can get it. I'm glad, Greg, that we're talking about this at the third week of June here, or maybe the fourth week of June, rather than in November or December. At least they appear to be ahead of the game. Hopefully they can get it across the line.
But the fight will be on once it gets into conference committee, right. And then they got to somehow merge those differences that they have on that too. Yeah. That's really where the work is going to have to be done once you get the Senate version. And it's not as easy for the Senate to get it done as the House was. But then when you get it into conference committee, that's really where it comes down to brass tacks. So we'll keep our eye on this. Quickly, just a couple of things on renting versus leasing farm equipment.
Yeah, I get this question quite a bit. Should I rent my equipment? Should I lease my equipment? And the answer is it depends. It depends what your financial situation is, what your cash flow situation is, how you can structure the lease. Is it a capital lease? Is it an operating lease? And that, depending on how you structure it, you might be able to deduct the lease payments. You might not be able to deduct the lease payments and any interest that goes along with it. And then, really, Greg, you need a full tax analysis by a CPA or a tax attorney or an accountant to get you the best picture so that you can make a determination as to whether leasing or buying farm equipment is best for you. And some people like to change equipment lines every couple of years. They like the newer technology. Well, maybe leasing works better in that situation. Other people use old farm equipment and just keep working with it, and ownership is good for them. So it really depends on each particular situation, both on the tax and non-tax side of things.
And all that we discussed today, they can find on your blog and Substack?
That's right.
All right, sounds good. Roger, as always, appreciate it. Thanks, and we'll talk to you in a couple of weeks.
Thank you, Greg.
That is Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the Ag Issues program here on 580 WIBW.